you're a small business registered in the United States, listen up, because there is a new filing requirement that comes into place on January 1st, 2024 that you should probably know about because it will most likely apply to you. This is a federal filing requirement, so it doesn't matter what state you're registered in. In fact, it will apply to pretty much every small business in the United States that's registered, whether you are a single or a multi-member LLC, an S-Corp, a C-Corp, or even a business trust. This filing came into place as a result of enactment of Corporate Transparency Act of 2021. As a result of this legislation, a whole bunch of small businesses in the United States will now be required to disclose certain information to the US Department of Treasury, and specifically to their branch called Financial Crimes Enforcement Network, or FinCEN for short. Yes, you heard me right, financial crimes. It doesn't matter whether you're involved in financial crimes or not, you will have to most likely file this report unless you fall under some exemptions that I will talk about later in the video. So now you're probably wondering, what is this mysterious filing that I'm talking about? Well, it's called the Beneficial Ownership Information Report, or BOI for short, or BOI, or BOI. And oh boy, do I have some news for you. Okay, let's unpack this filing step by step. First, where and how to file this report. You will have to file it directly with the federal government, specifically on the FinCEN website, and it will be completely free of charge, which is nice. Unfortunately, as of recording this video on December 16th, 2023, I cannot show you how the report looks like because it's not yet available on the website. However, it should become available on January 1st, 2024, because that's when the requirement comes into place. Second immediate question, do you have to file it on January 1st, 2024? No, but for existing entities, you need to file it as soon as possible. And for entities that will come into place during the year 2024, you will have 90 days to file this report. And starting on January 1st, 2025, all new entities that are created will only have 1 month or 30 days to file this report. And most importantly, what information do small businesses need to disclose to the federal government as a result of this filing requirement? Well, in order to fully understand and comprehend the importance and the goal of this reporting, let me quote the acting director of FinCEN, who's been in this role since August 2021, I believe, and I'm gonna butcher his name completely, so I apologize, and I'm gonna put his name on the screen here, and I will need my notes for that. So his name is Himamuli Das, and this is what he said. The Corporate Transparency Act, through its beneficial ownership reporting requirements, provides the historic opportunity to unmask shell companies and protect the US financial system from abuse by money launderers, drug traffickers, sanctioned oligarchs, and other criminals. That's what he said. And so, keeping that quote in mind, let's look at what information you need to disclose. And as far as I understand, there are two kind of aspects to this reporting. First is the information of the business entity itself. So obviously you'll have to disclose the legal name, and if you have a doing business as or DBA name of the business, obviously you'll have to specify that, the EIN of the entity, the address, and the jurisdiction of formation. And in addition to that, you'll have to disclose personal information of the beneficial owners of the legal entity in question. And beneficial owners, specifically for this filing requirement, are defined as people who are in control or who own at least 25% of the interest in the business. And in addition to beneficial owners, there are also applicants, though this requirement only applies to new entities that are created starting on January 1st, 2024 forward. For those entities, you also have to disclose personal information, not only on beneficial owners, but also the applicants. And applicants are the individuals who actually go ahead and file the paperwork to register the entities. So what exact information is required of these beneficial owners and or applicants? Well, obviously their full legal names, birth dates, residential addresses, and an identifying number that comes from either a driver's license, a state ID, or a passport, along with the picture of that ID where you derive that number from. As far as I know, this report is not an annual report that you have to file every single year. However, every time there is a change in any of the information that's required to be disclosed, you have to update the filing, and you will have 30 days to update the information on the entity itself or the beneficial owners, etc., etc. So now let's discuss penalties. And oh boy, those are harsh. There are two types of penalties, and they apply if you willfully do not file the report or furnish false or fraudulent information. So the civil penalty goes up to $500 per day of the report being missing or containing false or fraudulent information, and the criminal penalty goes up to $10,000 and or imprisonment of up to 2 years. Earlier in this video, I mentioned that there are exemptions. There are companies and businesses that do not need to file this report. There are 23 exemptions, and I will not discuss all of them. I will put them here on the screen. And also, if you're interested, I will put a link in the description box of the video, and feel free to follow me on LinkedIn because I posted an article specifically identifying those 23 exemptions. But I do want to discuss some of them because it's actually kind of amusing when it comes to looking at the exemptions. So notably, large operating companies do not have to file this report, and they do define what a large operating company is. It's a company that employed more than 20 full-time employees in the United States with a presence in the United States, such as an office, and also a company who derived more than $5 million in gross receipts or sales in the previous tax year. In addition to large operating companies, there are other exemptions, and I will be referring to my notes here. I hope you don't mind. As you can see, those exemptions include tax-exempt organizations and publicly traded companies that don't have to file this report, but also a whole bunch of financial institutions such as banks, credit unions, depository institution holding companies, money service businesses, brokers or dealers in securities, insurance companies, financial market utilities, pooled investment vehicles, just to name a few. So the 23 types of exempt business entities that don't have to file this report are considered to be not high risk for money laundering activities. And by the way, if you don't know what money laundering is, I'm not going to get into detail in this video, but I will put an article in the description of the video by Investopedia for you to read more on it. But in short, to describe what money laundering is in a few words, is basically a criminal's attempt to make dirty money look legitimate. And the reason they do it is because they need to have access to banking system and being able to transfer the money from one place to another and actually use the money for legitimate purposes. And I guess you all know what dirty money is. It's money derived through illegal means or money that was stolen or something like that. I find it very amusing, and maybe it's just me, that this report is designed, as I quoted this acting director, to protect the US financial system from money launderers, oligarchs, and other criminals, while exempting banking sectors, financial firms, large companies from filing this report. It sounds a little bit counterintuitive. I have to be fair though and say that yes, most of the entities in the list of the 23 exemptions, such as large companies, publicly traded companies, financial institutions, banks, credit unions, they are highly regulated entities, and they probably already file at least something very similar to this report. So forcing them to file the beneficial ownership information report in addition to all the other paperwork that they file will probably not make it any more transparent because they're already disclosed an enormous amount of information with the federal government, with the SEC, and a bunch of other federal agencies, as well as state agencies. However, forcing pretty much every small business registered in the United States to file this report sounds like an overkill. Is it just me or not? Money laundering can be a problem in small business, that's true, but it usually revolves around specific types of businesses, such as obviously casinos or taverns or restaurants, even car washes and taxi companies, or currency exchanges, and even art galleries or laundromats, pun unintended, I guess, or NFTs, cryptocurrencies, all that stuff. Yes, I understand, but if you run an Etsy store, if you record a podcast, if you vlog for YouTube, if you're a tutor or a coach and you happen to have a registered LLC, now you have to file this form? Really? Sounds like a little too much. Well, before I let you go, and if you're still here with me, thank you very much, I want to point a Forbes article that I will also put in the description box. And this article talks about a small business lobbying firm called the National Small Business Association that filed a lawsuit against the US Treasury Department, specifically for this enforcement of this BOI report. And they basically say that the new reporting rule violates the US Constitution, saying that it is unduly burdensome on small firms, violates privacy and free speech protections, and infringes on states' powers to govern businesses. I don't know how this report violates free speech protections, but when it comes to privacy, you're gonna be filing it, as I said, directly with the federal government, and it will be stored on the federal government's secured networks. As a follow-up to this comment, I now realize I forgot to tell you who is gonna have access to the information that you report on the BOI filing. According to the Corporate Transparency Act, this information will be limited to only authorized requestors. I think we all know what those are. Obviously, the Department of Treasury will have access to it, federal law enforcement, national security agencies, state and local law enforcement will also have access to this information, but with a court order. And in addition to that, financial institutions will have access to it, but with the reporting company's consent. And there are hefty penalties and fees in case this information is disclosed inappropriately or to unauthorized requestors as well. Alright, that will do for today. I hope if I didn't entertain or amuse you, then at least I didn't scare or stress you out completely. I am a New York licensed CPA and I work on US income tax compliance for businesses and individuals. So if you have a tax-related question, feel free to reach out to me on my website, lidiacpa.com, or via LinkedIn. The first consultation is free. And I hope to see you in the next video, and take care in the meantime. Bye!